simply testing whether
Good evening, Dr. Chauke. It seems that you are still going to be detained here. Good evening, Advocate Riley.
She'll be on her seat, Madam Chair, in a second.
Good evening, Advocate Riley.
Good evening.
You continue to be under oath.
It is correct.
Before you proceed, my sister is going to ask you to continue with her question. We are now connected. But before she does that, let me do some housekeeping. Advocate Ngcukaitobi, we request that in an hour's time, we pause. It's for a few minutes. You can join us in chambers so that we can do some few housekeeping matters about next week. Then we can reconvene. So if within an hour you'll still not be done, we will nonetheless pause for a few minutes. Then you can join us in chambers and reconvene.
Reconvene back here.
Back here. Yes, thank you. Please take note, all of you. You can come to chambers, then we can discuss about next week. You may proceed, my sister.
Thank you, Chair. Advocate Riley, can you hear me?
Yes, ma'am, I can hear you.
Okay. When we adjourned, we were on page 0164, and I'm going to ask you only maybe 2 questions or so. Look at, you had read into record 81.1, 81.2.
I'm just trying to find that page.
SR 0164 of your statement.
It is correct.
Okay, thank you. Now, do you see paragraph 81.3?
That is correct, yes.
Will you please read that paragraph into the record?
Check Jacobus Stale, in brackets 826, attached hereto as SA 5A, in brackets 4, whose finding was that the deceased was lying on the bed with his head on the pillow when all the wounds were inflicted, and further that the revolver, as depicted on the scene photographs, was defective and not capable of discharging ammunition.
Okay, yeah. Now, that says that the revolver that was next to the deceased was defective and not capable of discharging ammunition. You confirm that?
That is right. I confirm that.
Thank you. Then read paragraph 82.
The modus operandi was further explained in a detailed statement by Danicus, a police reservist who worked closely with Boyson, Annexure NJ3, referred to above. It was corroborated by ballistics reports supporting the allegations that those killed were not in fact resisting arrest when they were killed. Some corpses show execution-style head wounds. Danika's statement, which was later supplemented as detailed in Mahema's state affidavit, has since been signed.
Yes, this says that statement of Danika's, whether signed or not, but it was corroborated by ballistics reports. We are in agreement about that.
That is what he says, yes?
Yes, and the rest now, it deals with each and every case concerned, and it will not be necessary for us to proceed to deal with that. I think it has been dealt with in detail. And Advocate Riley, that is the end of my questioning. Thank you.
Thank you.
Yes, thank you, Advocate Ngcukaitobi.
Thank you, Madam Chair. Advocate Riley, can I just ask you to start with, this is a disciplinary inquiry against Advocate Chauke, and the allegations which you said you were familiar with are that he supported or endorsed or promoted a decision to charge Major General Boyson and others with racketeering despite no evidence. Correct? You are familiar with that?
That is correct, yes.
Yes, and one of the, in fact, the only ground upon which he has been charged in relation to the Keitomano issue is your report, correct?
If I read the charges, that is correct, yes?
Yes. Did you recommend that he should be charged with misconduct?
No.
Yes. And so that was a decision of the NDPP, not your decision.
I wasn't involved in that decision.
Yes. Now,
I beg your pardon? What's the answer?
says, well, can you repeat your answer, Advocate Riley?
I wasn't involved in that decision.
And your recommendation is made a decision. That decision is then set aside by the High Court. On the logic of Advocate Batoi, you would be guilty of misconduct.
I'm not guilty of misconduct. I disagree with you.
No,
I was part of a panel of 4 people. We were requested to review the evidence, which we did, and we made recommendations to the NDPP.
I
We
understand.
did not tell her to follow those recommendations.
I understand precisely. That's exactly what happened to Advocate Chauke. He was not a decision maker. The decision maker was the NDPP. He is charged for recommending and supporting, which is precisely what you have done. And he is also charged because he comes from Gauteng and is involved in matters from KwaZulu-Natal. You come from Cape Town, you are involved in a matter in KwaZulu-Natal. So it seems to me that it's hypocritical for you to say, no, you should not be charged, but Advocate Chauke should be charged.
I didn't institute any charges against Advocate Chauke. I never said he should be charged. You are there, you are incorrect.
I see. So you would agree then that it would be wrong to charge Advocate Chauke merely for making a recommendation which is not binding on the NDPP?
I did not make the decision. Neither do I know on what basis that decision was made.
I understand that, but if you want us to go through the terms of reference, we can do that. It's clear on what basis the decision was made. I'm simply testing whether there is consistency inside the NDPP's office. That's why I'm asking you that you cannot be a hypocrite. It is either you agree with me that if the MK party succeeds, you should also be charged with misconduct, or you say, I don't agree with you, in which event that applies to you and it applies to Advocate Chauke. It's as simple as that.
It's not as simple as that. Like I said, in our line of work, we make decisions every day. We also ask for opinions, and this was exactly what has transpired, to make a decision and recommendations to the NDPP. She wasn't bound by our recommendations. She says it in her internal memorandum to us that the final decision will lie with her.
Yes, but
In respect of the charges, I was, like I said, right, in respect of your first question, I was not involved in any way with the decision to charge Advocate Chauke.
yes, but I'm asking you for your opinion now. I hear what you're saying. Whether or not the DPP of South Gauteng, who is in the exact same position as you, was correctly charged for making a recommendation that is not binding on the NDPP. What's difficult in committing an answer to that?
Because I was not involved in that decision. I don't know on what basis the decision was made to charge him.
Well,
If you can explain to me that, then that's fine. But I wasn't involved in that decision.
okay, let's look at the basis for it. I'm going to ask you to look at the terms of reference, which set out the basis. I need my copy of the terms of reference. Oh, I don't have Are you able to find it, Advocate Riley?
Can you refer me to where I can find it? Then I can ask Advocate Lekito to assist me.
I'm sure she can find it. She knows her way around the papers. It's in various parts.
I do have it now.
Thank you. If you can turn to page number 6, paragraph 3.1.1.1. Can you see that?
That is correct, yes.
Yes. Now, the opening paragraph there talks about racketeering certificates, correct?
That is correct, yes.
And it's common cause that racketeering certificates are within the exclusive jurisdiction of the National Director of Public Prosecutions, correct?
That is correct, yes.
Now, 3.1.1.1 accuses Advocate Chauke of supporting a decision, not making it, supporting a decision to charge Major General Boysen, correct?
That is what it says, yes.
You would agree that he's not a decision maker, someone else is a decision maker, correct?
That is what it said, supported a decision.
All right. If you then go to 3.1.1.2, it talks about recommended, correct?
That is correct, yes.
And again, even there, he's not the decision maker, he's merely recommending, correct?
That is correct, yes.
Now, that is what I mean when I say he is in exactly the same position as yourself, where you are either supporting or recommending a particular decision, but it is not your decision, it is the NDPP's decision. So this is the basis of the charge that you were looking for. Now, I come back to my original question. If you say, if this decision is subsequently set aside of Advocate Batoyi, you should not be charged for supporting or recommending, you must agree that even Advocate Chauke should not be charged for supporting and recommending.
didn't draft these charges.
I know you didn't, and I am asking you deliberately because you are in exactly the same position as Advocate Chauke, that it seems to me it's logical, unless you want to be hypocritical, that if you say you should not be charged for supporting and recommending, it must apply to Advocate Chauke. What's difficult in saying what's good for you is good for him?
Are you able to comment, Advocate Riley?
I'm not able to comment because I was not part of this decision making. To charge Advocate Chauke, I don't know the basis for it, and I didn't draft any of these charges against him.
So your answer is, should we understand your answer to be no?
That is correct, yes. I did not, I was not involved in this decision to charge Advocate Chauke.
No, that's not the point. The point is not whether you were involved or not. The point made by counsel is that if you are similarly placed as Advocate Chauke, or in the position similar to Advocate Chauke, because in your report, together with your colleagues, you supported and made recommendations in relation to racketeering authorizations to someone, well, let me put it directly to Advocate Batoyi, who has the power to decide on those racketeering authorizations. She has exclusive powers to decide on these racketeering authorizations, not you, not Advocate Chauke. And counsel is saying, because you are in the same position, doesn't it then follows that if Advocate Chauke, who is in the same position as you, who is alleged to have done what you did in your report, should then make you to be in the same position, and therefore you should also be subjected to the disciplinary hearing? Because you supported and recommended on the decision on the matter that falls within the exclusive powers of the NDPP.
And you come from Cape Town.
And yet you come from Cape Town.
Once again says, I do understand. We gave an opinion. We also made certain recommendations in respect of whether they said he supported a decision. I can speak to what we did in terms of our recommendations, but I cannot speak to what is in 3111 and 3112 as to why those charges were put.
No, Advocate Riley, it's very simple. I can tell you, it's very simple. They are saying Advocate Chauke is from Johannesburg. He's getting himself involved in matters that are in KZN. And he is exceeding the scope of his jurisdiction. He's violating the law. That's what they're saying. Advocate Batoyi said this many times. I look at this report you've prepared. I see that the other two gentlemen are deceased. The two that remain is yourself and Advocate Tenga. Unfortunately, you are the only one who's testified here. That's why I'm putting to you that if it is misconduct to make a recommendation on a matter from KZN that falls within the exclusive power of the NDPP for Advocate Chauke, it is also misconduct to you, should you now also receive your charge sheet? That's the simple question.
You indicated, and that's what I'm trying to indicate, what the evidence, on what basis they are saying he supported a decision in his capacity as the DPP. You now mentioned the fact it's because he was the DPP in South Gauteng and he tried to improperly have the acting director of public prosecution, KZN, sign the case dockets or a prosecution memorandum. That's the basis. That's not an opinion. That's not an opinion. And I keep on saying, we were asked to provide an opinion and recommendations. That charge is different. And on what basis and what evidence they have to support that charge, I am not privy to it.
All right. So you would say the mere fact that he provided an opinion or supported a decision or made a recommendation on a matter that is from KZN, the so-called exceeding the jurisdiction charge, you would agree with that or not agree with that? I just want to get a clear answer because it seems to me you are similarly placed.
I'm not similarly placed.
All right.
As I indicated, the allegation against him that he sought to improperly have the acting director of public prosecution, KZN, sign the case dockets and or prosecution memorandum, I cannot speak to that. But that's very different from granting an opinion, reading dockets and giving an opinion to the NDPP.
Yes, I see. So if it was only about granting an opinion and making a recommendation, that wouldn't be a charge, even if you came from a different jurisdiction.
That is correct.
Thank you very much.
It's very much different from somebody interfering, in my opinion, in the work of another DPP.
No, that's all I wanted to confirm. Thank you for that. Can we then move on to the next topic? If you go to your statement, particularly at paragraph 101.3, and it is a question that was raised by Advocate Baloymere SC.
It's one, sorry?
Paragraph 101.3 of your statement.
That is correct, yes.
Yes. Now, in this paragraph, it says, in Durban Central CAS 18502-2009, Pinetown CAS 1005-2009, Rustenburg 109809-2009, there was evidence that Bongani Mkhize was one of the orchestrators of the murder of Nkosi Zondi. The information was later confirmed by Swayo and Siphem Hlongo, correct?
It is correct.
Yes. Now, you've given this statement under oath, is that correct?
That is correct.
Yes. Now, the question that was raised by Advocate Baloymere was that in 2009, 2010, there was a trial of Mr. Swayo and Mr. Mkhize. It started off with a bail application. Mr. Swayo was granted bail. He was shot and killed immediately after that bail. Mr. Mhlongo stood trial and he was acquitted. The evidence they gave, which implicated Mr. Bongani Mkhize, was obtained under torture. That was the evidence in that trial. We've got the full transcript before us. We played it before the panel. Mr. Zungu accepted that that evidence was obtained by torture. Now, I want to understand why, as the Deputy Director of Public Prosecutions, you are relying on information obtained under torture.
As I indicated when I was asked that question, I was aware of the judgment, but I wasn't aware of the information regarding the judgment.
No, you see,
I was aware that they were found not guilty.
no, you see, I cannot accept that because Firstly, this is information that has been in the public domain since 2010. You did your report in 2019. Secondly, this is evidence that was led in this inquiry only 3 weeks ago. You are still relying on information obtained under torture. That's what I want to ask you. Why are you intentionally relying on information obtained under torture as a lawyer?
Whether it was in the public domain or not, I wasn't aware of the evidence that was led during this inquiry. I work every day. I don't follow the proceedings every day. So I'm not aware that that evidence was led. The information was that there was a not guilty. I indicated that we were not privy or read the judgment. That I will concede in respect of that. And if you want to determine that was grossly negligent or that is your prerogative.
Yes, but how do you describe your failure in the light of your knowledge that the two were found not guilty? Your failure to find the judgment, to read the record, because it was all public knowledge. Even the acquittal of Mr. Mhlongo was reported in the newspapers. Even the allegations of torture were reported in the newspapers. So if it is not gross negligence on your part, how do you describe it?
Once again, that's your prerogative to call it gross negligence. I don't agree with you. I said to you, we were aware that they were found not guilty.
I'm asking the fact that this was all public, the fact that it didn't come to your attention. I'm saying I'm describing it as gross negligence. You say you don't agree. Give me the correct description of your failure to get information that's in the public knowledge.
We were aware that he was found not guilty.
All right. Now,
I indicated to you, you're more than welcome to call it gross negligence, and I don't agree with you.
Yes. Can you tell me something else? It is the second time in this inquiry it has been brought to your attention that you have relied under oath on unconstitutionally obtained information, obtained under torture as if we are still under apartheid. Do you want to retract that part of your statement or not?
I will go read the judgment, and then we can return back to that.
No, I'm telling you now that the information was obtained under torture, and I'm asking you if you want to retract that paragraph or not.
I said I will go read the judgment, and once I've read it, and as a legal person, properly applied my mind to the judgment, I will then be in a position to give you a response.
So at the moment, you are not prepared to say information obtained under torture cannot be relied upon by the NPA.
I never said that. I said I will go read the judgment, and once I've read the judgment, we can come back to 101.3.
Yes, but I'm asking you a different question now, which is, are you prepared to accept that information obtained under torture cannot be relied upon by the NPA?
As a matter of principle.
The evidence during...
Maybe put it this way, Advocate Riley. As a matter of principle, if it is correct, and it is correct because we have read the judgment of the court that the information was obtained under torture, and there were statements to that effect. Regrettably, you have not read the judgment, but it is a fact now that there is such information, that the statements obtained from these accused persons were obtained under torture. As a matter of principle, as a prosecutor, you cannot rely on information obtained under torture. Correct? Because there's a judgment that says so. There are statements that say so, and the court has found that such information was obtained under torture. It's not a speculation. In that event, would you, as a prosecutor, rely on such information when the court has pronounced on its unreliability?
In respect of that, if a court has found that the evidence is unreliable or inadmissible...
The court, I can tell you now, the court has found that such information, having been obtained under torture, cannot be reliable.
That is correct.
Now, as a prosecutor, having that judgment, can you rely on information obtained under such circumstances?
No.
Thank you.
Thank you, Madam Chair. Just one more point on this topic then. I'm not going to repeat this. I think we've explored this enough. You admit that you were aware that this gentleman, well, the first gentleman, Mr. Nkcukaitobi, was killed while he was on bail. The second gentleman, Spamandla Mhlongo, was acquitted. Then why rely on the confession that he made as to the killing of Mr. Bongani Mkhize?
There was evidence. Like I said, I did not read the judgment. So the fact that he was acquitted, if I've known that he was acquitted as a result of unconstitutionally obtained evidence, we would have revisited that decision.
Well, I suppose that takes us back to where we started, which is this was all publicly available information. So your point is that it is simply because you were not aware of the unconstitutionally obtained information that resulted in the Sections 174 discharge.
That is correct, it happens.
But doesn't that make your report entirely unreliable?
No.
I see.
Not entirely. That is incorrect to say that.
Well, your report in relation to these findings that we have explored, it is entirely unreliable.
Unreliable in respect of 1013?
Yes.
Yes, potentially.
Thank you very much. Can we then move on to the third topic? Now, you submitted to us earlier a list of dockets considered by the de Kock panel.
That is correct.
Yes. Now, that was a list you considered in 2019, correct?
That is correct.
There were 28 people that were killed, correct?
That is correct.
24 of those people had no warrants of arrest. Only 4 had warrants of arrest, correct?
That is correct.
Yes. All of them happened to be a black African man, correct?
That is correct.
According to the evidence of Mr. Danikas, there was racism throughout the Nkcukaitobi unit. Did you ask yourself the question, why only Africans are being killed by this unit?
No.
I see.
I looked at the dockets, the evidence, and that was the decision that we had to make in terms of whether there was sufficient evidence. I did not look at the race of the person.
I'm asking you, oh yes, I see, the race, you didn't see that it was only Africans that were killed, I guess.
No, I did not say that. I said we did, when we made our decision in our dockets, we looked at the evidence.
I understand.
You did not look
I'm
at
asking
the
you
race.
a race question. Intentionally asking you a
I don't
race question.
understand how's that relevant.
Because-
I explained to myself
I beg your
that I was
pardon.
looking
I
at
beg
the
your
evidence
pardon.
in the
I beg your
docket.
pardon, Advocate Riley. Please don't have an attitude. You are an advocate. You are well vested with procedures in court. You lead witnesses in court. You cross-examine witnesses in court, and you should observe the court decorum. We expect better from you. Please.
Apologize.
If you need to pause because you need to compose yourself, please ask so that we can give you a chance to pause. We all understand that cross-examination is not easy for anybody, but don't.
It's also late in the day, ma'am.
It's late.
Madam Chair?
It is late in the day. We started late. We had an opportunity to start early. Yesterday, we were made to wait the whole day because we are going to file a supplementary statement, which has never come forth. And we lost 1.5 days. And it is as a result of that that we have to sit until late. This delay cannot be put at the door of anybody except you. Because you made us wait when you had signed an affidavit over the Easter weekend, which we read, and we thought that we were going to start on time. But you said you are not available. You will only start on Tuesday after lunch. So we lost 1.5 days. That is why we are sitting until late, to make up for the lost time. If you need to pause, we are prepared to grant you the indulgence if you ask, but please answer the questions.
Thank you, Madam Chair. Advocate Riley, I'm not going to leave the question of race. I want to know whether you noticed that only Africans were being killed by this unit.
That is correct. I said it before that they were African males that were killed.
Yes, but you noticed that in 2019 when you did your evaluation.
That is correct.
Yes. Now, there are two witnesses. One was called here, the other was not called. The one that was called is Mr. Ari Danikas, who said that there was a racist pattern embedded in Nkaitomano, which included the use of the K word. Were you aware of that?
In his statement.
Yes, in his statement to this inquiry, yes.
That is correct, if it's in his statement.
Now, that's exactly the point I'm asking. You have a group primarily of white men, Van Tonder, Lockham, Mostert, Boysen, executing African men. Didn't this play a role in your evaluation about the possible explanation? The reason I ask you this is because Mary de Haas wrote a letter to Advocate Batoyi and asked in the letter, if the deceased had been white, would you respond in such a careless fashion? She never got a response to that. And I ask myself this question, even to yourself. If the deceased had been a different race, would you be so nonchalant in the way you have dealt with them?
I don't agree with your term nonchalant. As I explained it on several occasions, we studied the docket. That is my role as a prosecutor, to look at the evidence in the docket. So I do not agree that it was done nonchalantly. I have submitted SR5 That is our work document in which we looked at each and every docket that were given to us, the 26 dockets. I can't respond to the letter that was sent to the NDPP.
Let me show to you why this was such a poorly executed job, that it shows that you didn't care about what you were doing. That's what nonchalant means. It means I don't care. You prepared a report in which you listed 22 dockets that you covered, correct?
In the report,
Yes, the report you gave us this morning, list of dockets considered by the DCOC panel.
can I just, are you referring to, just hold on. That is correct, yes.
Yes. Out of that, Captain Mangena appears 5 times. He appears on paragraph 6 under Durban Central, correct?
That is correct, yes.
Under item 10, Melmoth, correct?
That is correct, yes.
Under item 12, which is Phoenix.
That is correct, yes.
Under item 14, Eskaweni, the first Eskaweni.
That is correct, yes.
And then under item 16, the second Eskaweni. Correct?
That is correct, yes.
Yet, you knew that according to the evidence of Advocate Sean Abrahams, Captain Mangena had done 19 reconstructions. Correct?
If I understood it correctly, yes, he did several reconstructions of the crime scenes.
No, he did 19 that were considered by Advocate Sean Abrahams in the answering affidavit that you've referred to in your own statement.
I can't specifically remember, but I am not going to disagree if that's what the statements say.
Look at SR 0271. Paragraph 539.
That is correct, yes.
And that's where the number 19 comes from. Can you say that?
That is correct, yes.
It is only a person who doesn't care about what they are doing who will pick 5 reports out of 19 for analysis. That's the point I'm making.
If 19, they were not all 19 dockets that form part of the indictment and the prosecution memorandum. If you can tell me that is what it is, the 19 out of the 26 dockets, then I will agree with you. But you need to be able to show me that there were reports. How many reports were in those dockets?
Well, this is exactly why we have included all of the reports in the cross-examination bundle, which you did not consider. I'll give you the names now of all of the reports that were in the dockets that you didn't consider.
We can go through those reports, and I will give you an indication whether that report was ever in that docket or not.
Well, I am telling you, we found them in the dockets. These were circulated to this panel.
In all the dockets?
Yes.
Because I double-checked it against the dockets that were handed in at the inquiry. Because that is exactly why I requested an opportunity to look at the Mangena reports. Because if my recollection was correct at the time of 2019, there were not in each and every docket a report of Captain Mangena.
Let me tell you those where the reports were. Berea, case 288/05/2008. It does not appear from your list.
I once again want to reiterate, if those reports were in the dockets as an A1 or A5 or 94, then I will accept it. But I double-check, for example, the Berea case 288/5 of 2008, and I counter-checked it with the docket that was handed in at the inquiry. And I could not find that report at the docket handed in at the inquiry, and neither could I find that docket in the docket that was scanned and put on a disc and handed to the prosecutors, Advocate Tekok, Advocate Ivy Tenga, Mama Bola, and myself. There was no report filed in that docket. And we can go on to the other dockets.
Next
as well.
docket, Rustenburg, case 1090.
Before that, Counsel, Advocate Riley, look at number 9 in the list. Berea case 288/05/2008, ballistic report analyzed. And Counsel has just asked you about Berea, and your answer is inconsistent with the listed number 9. Berea, ballistic report analyzed. You remember why this list was provided?
I do remember. Can I respond, Madam Chair?
Yes, ma'am.
If I understand, if I look at the index to Advocate Riley cross-examination bundle, number 12.
Sorry, Madam Chair.
Counsel, I'm sorry.
Yes.
You did not have the ballistic report of Captain Mangena in the dockets as at the time you prepared your report?
That is correct. It was not filed as in the A section.
Yes. You said you wanted all of them. Let me continue listing them. You did another one for Kwadukuza, case 3909/2008, not part of your report.
Yes, hold on. Let me just check.
Sorry, Advocate Ngcukaitobi, maybe as you call them out, because apparently they are filed under Section A. If you have the A number there, it would really assist.
They are in. Oh well, Mr. Ramukhale says I'm holding his computer. All right, I'll give you your computer. Are you finished looking, Advocate Riley? There's another job we will do, which is looking for the A number, but I'm just giving you the reconstructions that have been presented to this panel of the dockets that don't appear in your own report.
You indicated the Kwadukuza.
Yes.
Which case number is that?
3909/2008.
You're absolutely correct. There was no Mangena report, but I did make a note in my SR5 that, in fact, when I read these dockets, that docket specifically, there were no any other ballistic report in the docket.
Rustenburg.
I do say Rustenburg.
Yes, case
Just hold on.
1097, stroke 09, 2009.
Just hold on. There was no report from Captain Mangena, except for a ballistic report of ballistic examiner vessels.
I understand that. Escort, case 3408, 2008. The point is that these are not in your report, but they are in the answering affidavit prepared before you did your report.
They are not in the docket.
Well, this is where I am heading. Can we just finish the job? We've got three more to go. Escort, case 34, stroke 08, stroke 2008. Do you admit that that is not in your report?
Can you please just, can I ask the chair if the advocate can just give me an opportunity to actually go to that specific case number so I can double check my note as to whether there was a report or not.
Escort, case 3408, 2008.
There was no Mangena report in that docket.
In the escort docket.
That is correct, yes.
Yes.
Kwamashu, case 314, stroke 11, stroke 2008. That's also not in your report.
You can have a look before you answer. We have two Kwamashus. Which one is that?
This is, Madam Chair, this is 314, stroke 11, stroke 2008. I'm coming back to this.
Is that the case number?
The case number is 314, stroke 11, stroke 2008. It's number 19 on the list of the witness. Thank you.
Thank you.
In that matter, similarly to other matters, and I double-checked it against the docket that was handed in at the inquiry, there was no report filed in the A section, B, or even C of that docket of Captain Mangena.
Pinetown, that's the last one. Pinetown case 1000, stroke 05, stroke 2009.
There was no report of Captain Mangena in that docket, and I double-checked it also with the docket that was handed in at the inquiry.
Yes. Well, thank you. Now, the point of this exercise is to show that at least 6 reports that have been presented here are missing from your analysis. According to Advocate Abrahams, there were 19 in total, which you've attached. I do not understand why you didn't ask for them at the time you were doing your job.
If you can confirm that all 19 relate to the 28 dockets,
Well,
I will understand that. But if I looked at your list that you have also provided, there are many other dockets that did not form part of the 28 dockets. For example, number 28, Tokoza CAS 1766 of 2011. Docket did not form part of the 26 dockets. I can list you perhaps another example of another matter. Heidelberg CAS 8911 of 2010. That docket did not form part of the 28 dockets.
No, the 6 I read
Certainly,
are
don't
only taken
pop
from.
Yes.
Yes, the 6 I read are taken from the 23 only. They are taken directly from the indictment.
6, yes?
Sorry, I don't hear your answer.
Advocate Ngcukaitobi, you are exchanging information from some lists. She's talking about Heidelberg, and where is that?
I think she is talking about the...
She says the list comes from you.
It is the index to the Riley cross-examination bundle. That's what she's talking about.
Where do we find that?
It's apparently here behind me. I apologize, Madam Chair. I had forgotten to ask that it should be distributed. So what the witness is talking about is from paragraph item 12. So that's where all of them appear up until item 29.
Yes, thank you.
Thank you. Now, Advocate Riley, I'm again not leaving this question because I need to get clear answers. I've just put to you that the 6 I read, I intentionally focused on those that are in the 23. Do you have any comment to that?
Comment to you reading the 6.
Sorry?
I don't understand what you're saying. Sorry, can you repeat what you're saying?
You commented earlier, without being asked, that there are certain references to Captain Mangena's reports that are not part of the 23, correct?
I don't know the number, whether I said that. I just quoted which dockets we received, counter-checked against the dockets in the inquiry, and then whether we have a report of Captain Mangena. I don't have the exact number. I didn't count it.
No. Again, I am going to repeat this point because I don't want the record to be confused. You said, you read to me Tokoza, and you said that is an example of a report that does not form part of the indictment, correct?
That docket didn't form part of the 26 dockets, yes. That we studied.
Exactly. Now, I told you that the 6 I read out as missing from your report comes from the 23 dockets. That's the point I'm making to you. It's not any docket that is outside of the 23. That's what I'm putting to you.
I'm just trying to count which dockets we studied that had reports in.
Well, you gave us 5 out of the 22.
That is correct. That is correct, yes, 5.
Yes, now, this is the point. There is a massive discrepancy. By the time you did this, you were aware that according to Advocate Abrahams, there were 19 Captain Mangena crime reconstruction reports. You didn't ask for them. If I give you the benefit that when you open the docket, you didn't find it, you didn't ask for them, but you knew they existed. Can you explain yourself?
Now, I keep on asking, please, can you answer this? Are you saying that the 19 relates to the 26 dockets?
This is what Advocate Abraham says. Let's go back to that paragraph because I don't want the impression that, no, the witness didn't understand. You perfectly understand what I'm saying. We go back to SR 0271.
That is correct, yes, if he refers to the 26 dockets.
No, 23 cases which are in the indictment. And out of those, at 539, he then talks about 19 crime scene reconstructions.
That is correct.
That's why I'm asking you the question. I'm still expecting an answer. Why did you not ask for the copies of these reports which you knew existed and come from the 23?
As I indicated, we did ask Advocate Mahema for all the relevant evidence. If it was not in the docket, one would have expected him to have provided us with it because it was definitely not even mentioned in the C section of the docket.
You see, the problem is that we've got all of the exchange because it's attached to your statement that you had crime scene reconstructions. That would be very helpful.
It doesn't mention Mangena's report. That I will concede. What it does mention is that the prosecutor should provide us with all the evidence that he considered in respect of his indictment as well as prosecution memorandum.
All right, can you take us there? Can you open that? Open the attachments to a statement. So show us where the request is made. There's an exchange of those emails. Brilliant, yeah. Let's do after that. No, I know, but she must show us.
The communications was with between Advocate de Kock and it's SR 1081.
1081. Let's go there.
That is correct, yes. Was between Advocate de Kock and Advocate McAdam. He starts off by saying, I was advised by Danny Smith that you will be leading the panel. I'm trying to get all the material together, which is proving quite a challenge. Then he says, he explains further in the email how he's trying to obtain the files, the memos, and he also asked the DPP KZN for her files as the case is being conducted under her name.
No, sorry, Advocate Ryan. I just want us to do this job easy. You've said that Advocate de Kock wrote an email to Advocate Mangena in which he asked for all of the dockets. Just take us to that email.
I said, not all the dockets. I said, you are misconstruing my words. I did not say Advocate de Kock wrote to Advocate Mahema.
Well, I thought that's what you said.
What did you say?
We say, sorry, ma'am.
What did you say?
I said we tried to obtain all the relevant evidence, which included the dockets, to consider our decision on. That's what I said.
And you referred to the communication between Advocate de Kock and Mr. Mahema.
I didn't say that there was communication between Advocate de Kock and Advocate Mahema.
You see, we are writing notes here. You are not taking notes of what you are saying. That's why I'm looking at my notes and I'm asking you a question. The communication that you were referring to earlier between Advocate de Kock and Mr. Mahema, and then you mentioned the emails, at least in accordance with my recording or my writing. And the council is asking you, take us to the email.
What I meant was that there was, on the part of Advocate de Kock, we were seeking all the information, all the dockets, as well as all the files. That communication, and I apologize if it came across that I said that Advocate de Kock personally communicated with Advocate Mahema. That communication was primarily between Chris McAdam as well as Danny Smith. And that is what those emails referred to as Annexure 4 to my affidavit.
All right. So, in other words, there is no communication from Advocate de Kock to Advocate Mahema asking either for the Mangena reports or all of the dockets, correct?
Not between Advocate de Kock and Advocate Mahema. That I will agree with.
Yes.
But there are other communications between Advocate de Kock, Advocate McAdam, as well as Advocate Sibongile Mazinyati, where they explain that they have spoken to Advocate Mahema to specifically inquire about his alleged non-cooperation. He said he was unaware of the mentioned non-cooperation. He said he gave McAdam the original documents of all the dockets and documents and file is in his possession. He spoke to Advocate McAdam yesterday. He will give him the presentations that were made to the previous NDPP as part of the motivations for the racketeering authorization.
Yes. Now, the reason why this question is important is not simply to catch you out. It's because Advocate Mahema was the leader of the prosecution team. What he testified in this inquiry, he expected, is that he would be called in by your panel to explain the evidence they worked on, to explain the logic of their thinking, to explain their strategy. But that opportunity was never given. That's why I was curious to see the communication between the chair of your panel and the head of the prosecution team, which I cannot find.
I'm doubtful whether there is such communications between the chair of the panel, Advocate de Kock, and Advocate Mahema. I only aware of one email or one or two emails where Advocate Mahema responds to Chris McAdam and he will copy in Advocate de Kock regarding some of the information that was required, for example, the Danica statement.
Yes, I understand that. I don't know if you want me to repeat my question. But I guess you've already said I will not find what I'm looking for because it doesn't exist.
Yes, I agree with you.
Right,
there would be no communications between Advocate de Kock and Mahema.
Yes, thank you very much. Now, we have finished the analysis I wanted to make of comparing your report versus the existing objective information, and that you did not request. I want to move on then to my fourth topic.
Okay, Nkcukaitobi, we will pause at 8 o'clock.
Yes, Madam Chair. I think I can, yes, 8 minutes will be sufficient to cover this topic. Thank you. Advocate Riley, I want to ask you to look at the provisions of POCA. To let us know if you are struggling to do that. It's extracts, not the full section.
I'm just asking Advocate Legeto to assist me.
Yes, that's fine. Thank you very much.
You can do that.
Yes, I'm at 275, page 275.
Yes, if you are at 275, I want to ask you to turn your attention to a pattern of racketeering activity, the definition. Can you see that?
That is correct, yes.
means the planned, ongoing, continuous, or repeated participation or involvement in any offense referred to in Schedule 1, and it includes at least 2 offenses referred to in Schedule 1, of which one of the offenses occurred after the commencement of this act, correct?
That is correct.
So what is required here is the planning, the ongoing, continuous, or repeated participation in the offenses referred to in Schedule 1, correct?
That is correct, yes.
Yes. There is no provision here that says that your participation in those offenses must have been for reward, correct?
Just repeat that, please. I didn't hear properly the last part.
There is no requirement that the participation of the alleged offender must have been for reward, correct?
Must have been?
For reward, for payment, for profit.
Okay, yes, that is correct, yes.
If I can then ask you to turn your attention to the indictment itself, particularly under the heading Summary of Substantial Facts. You will find the indictment at 1078, which is item 30.
It's 1078 of what?
1078 of the cross-examination bundle, Madam
Bundle.
Chair. Yes, thank you.
You want me to turn to the summary of substantial facts?
Yes.
Which page is that?
It is at page 1157.
That is correct, yes.
Yes, if you turn over the page to 1158.
That is correct, yes.
Now, if we read together paragraph 2, the way the indictment describes the pattern of racketeering activity, it says, the unlawful activities of the enterprise began to manifest themselves in May 2008 to September 2011 through a pattern of racketeering activities, full stop. They killed members of KwaMaphumulo Taxi Association, which was in conflict with the Stenga Taxi Association, ordinary civilians, and or suspects and criminal gangs suspected of ATM bombings, correct?
That is correct, yes.
Do you admit that that section does not refer to killing for profit?
That is correct.
Yes. In other words, consistent with the definition of a pattern of racketeering activity, what we go to this issue of an enterprise. Now, what I want to ask you about an enterprise is firstly to take you to a judgment of the Supreme Court of Appeal, which is in item 8 of the cross-examination bundle index at page 295. Do you have the judgment called ASEN versus S?
That is correct.
If I can ask you, please, to go to the I think it's the last. It's the definition of I think it's paragraph 6, but I'm looking for the page where paragraph 6 appears. Yes, yes, page 298, paragraph 6. Do you have that?
Just reading, just hold on. What page?
298, paragraph 6 of the judgment.
Okay, it says the word enterprise, yes?
Yes, exactly. Now, firstly, it extracts the definition of an enterprise from the Act. We don't have to read that. We can see it, both of us, correct?
That is correct, yes.
I want to take you towards the end of that sentence. It is 1, 2, 3, 4, 5. The fifth line from the bottom that says there is no requirement. Can you see that?
That is correct, yes.
It says there is no requirement that the enterprise be legal or that it be illegal. Can you see that?
That is correct, yes. I see it.
So the enterprise itself can be a lawful organization. It is not necessary that the enterprise must be an unlawful organization, correct?
That is correct.
Yes. The unlawfulness is introduced in the second element, which is the pattern itself. And that is what the judgment says. It says, it is the pattern of racketeering activity through which the accused must participate in the affairs of the enterprise that brings in the illegal element, correct?
That is correct.
Yes, thank you very much. Now, I think you and I are completely ad idem on the meaning of an enterprise and the meaning of a racketeering activity, correct?
That is correct. That is correct.
Thank you. Madam Chair, it's 8 o'clock, so we may take the adjournment.
Yes, thank you. As I said earlier, you should all assemble in chambers. As we take a break, we will reconvene after, say, 30 minutes. If you can come to chambers, and we will come back. Advocate Riley.
Yes, ma'am.
We are going to pause for 30 minutes and we'll reconvene at 8:30.
Thank you, ma'am. I confirm.
Yes, thank you. You are still under oath, by the way.
I confirm that.
Thank you very much. more of a time that we did. Let me just apologize to all of you that we are taking a little bit more of a time that we didn't anticipate, but we won't be too long hereafter. Hopefully we will finish not before long.
Yes.
Thank you. Advocate Riley, you are still under oath, madam?
I confirm.
Yes, thank you. Advocate Ngcukaitobi.
Thank you, Madam Chair. Advocate Riley, before the adjournment, we had finalized conceptually the definition of a pattern of racketeering activity and the definition of an enterprise. We had also looked at the charge sheet or the indictment in relation to how it conceptualizes the pattern of a racketeering activity. You confirm that?
That is correct, yes.
Now, I just want to finalize that part by looking at how it describes the enterprise itself. You will find that at 1157 of the cross-examination bundle.
Please repeat that, Counsel.
Page 1157, Madam Chair, of the
1157.
cross-examination bundle, yes, under the heading Summary of Substantial Facts in the Indictment.
Okay, he's back.
Have you found it, Advocate Riley?
I have Advocate Ngcukaitobi.
Thank you. Now, if we look at paragraph 1, the South African Police Service is a legal entity established by legislation in terms of the South African Police Service Act, number 68 of 1995. It is composed of a national office and provincial structures for each province. So you can ignore all of that because that's not the enterprise. But the next sentence is the enterprise. The serious violent crime section, based at Kaitomano, was a section within the Durban Organized Crime Unit, which formed part of the KZN provincial organized crime structures and was therefore an enterprise as defined in the Act. Now, that must be correct in the light of what we discussed, that it would be permissible for the prosecutors to say the serious violent crime section based at Kaitomano, which is part of organized crime, is an enterprise, correct?
That is correct, yes.
Yes, all right. Thank you very much. Now, that takes us then to the two additional elements of this charge. Those are the elements of management and participation. We start off with the management part, which is at page 1158, how the indictment saw the management. Firstly, at paragraph 4, it says, the state alleges that the accused knew or ought to have known that the unlawful activities were against the provisions of Section 205 of the Constitution, South African Police Service Act, and Part 3 of Standing Order 251.6.1 and Common Law. Now, that is talking about participation. Would you accept that? Because it's all of the accused.
Participation or Section 21F, you knew or ought to have known?
No, they're saying it's all of the accused that participated in those activities, but they did so knowing full well that those activities are unlawful. Correct?
Okay, they said yes, they knew or ought to have known the activities were unlawful.
Correct, yes. In other words, they participated in those patterns, and the pattern is limited to the killings. Correct?
Correct, yes.
Now, then we come to another element, which is the management element, which you've agreed with Mr. Mtsweni that depends on knowledge of the unlawfulness. That you will find at paragraph 5. It's limited to the managers. Can you see that? 1, 6, 9, 15, and 16. And you know who they are: Mr. Boysen, Mr. Olivier, Mr. Eva, Mr. Van Tonder, and Mr. Lockham. Those are the managers, according to the indictment. Now, the way they are accused is that they knew or ought to have known that their subordinates were engaged in ongoing and continuous commission of unlawful activities as mentioned in the predicate offenses. And this would be permissible to charge a manager who knows that their subordinates are engaged in a pattern of racketeering activities, as themselves being implicated in the pattern of racketeering activities, correct?
That is correct, yes.
Yes. Now, I know that you have raised an issue about the extent to which the indictment clarifies why these 5 have been chosen as managers. You remember that?
That is correct, yes.
And specifically, you have said you cannot merely duplicate the official title into a pattern. You have to show that there are some facts of the role that you played in the activities of the enterprise, correct? A management role you played in the unlawful activities of the enterprise, correct?
That is correct,
That's been your
yes.
argument, yes. Now, I want to deal with that now, this is now topic 5. Did you consider the reply to the request for further particulars? It is a lengthy document. It's 1,052 pages long. And it's not referenced at all in your report, nor is it even referenced in your statement. Now, that document starts, if you look at the index we gave, it starts at page, it's item 31, starting at page 1,230 to 2,249. Did you actually ever read that document at all?
I'm just asking the advocate to assist me so I can just confirm whether I've read it or not.
1230.
That is correct, yes.
It's various parts. There's 5.1. Oh, that's okay. Very good. What page?
Is it in your bundle volume 3?
Madam Chair.
Because I don't have.
Oh, no, Madam Chair. It's volume 4, 5, and 6. Sorry, it's volume 4, 5, and 6. Yes. Now, what happened, Advocate Riley, just to put you in perspective, after the indictment was served in August of 2012, the evidence shows that Major General Boysen and the others submitted a lengthy request for further particulars. That was then responded to in, this was a further request.
Give us a chance.
Oh, sorry, Madam Chair.
We have 1230.
Yes, 1,200, yes, 1230, yes.
Yes.
That's where it starts.
This is a request for further particulars.
This is the request for further. Well, this is a response. No, actually, the chair is right. It says further particulars request of the accused.
Yes.
Yes.
At 1231.
Yes, at 1231. Yes. Now, this document is 1,052 pages long. The question to you is, did you actually read this document at all?
I can confirm that the panel never read this document.
Never read it.
That is correct, yes.
Yes, you see, now that is an extraordinary confession because a response to further particulars is part and parcel of the indictment. Correct?
That's correct, yes.
Now, if you have not read it, then it means your analysis is so deficient that it has no value because you did not read the full indictment.
Of what was said in respect of the further particulars.
Correct. Now, this is the reason I'm asking is that as a matter of law, a response to a request for further particulars is regarded to be part of the indictment. When you admit that you didn't read it, you didn't read 1,052 pages. What I'm putting to you, you can say I'm wrong. I'm happy for you to say that, is that your analysis that you gave to Advocate Batoyi was so deficient that it had no value because you did not read the full indictment.
Let's correct something here, Council. At 12:31, the bolded words in the trim lines seek to suggest that this was a request for further particulars. When you read the body of that document, please kindly take notice that the state hereby furnishes the following further particulars, which means it is a response indeed.
Yes, correct.
But the words in the trim lines are misleading.
Yes, no, they are. I was just saying you read it correctly, but because we knew what it is, then we said, no, it's a response. But we were wrong.
Yes.
Thank you, Madam Chair. So, Advocate Riley, I've put to you the proposition that your entire report, together with your statement, are so worthless because you did not read the full indictment. 1,052 pages of the indictment were never read by the 4 advocates that were asked by Advocate Batoyi.
My response to that question or submission will be that a request for further particulars and a response thereto emanates from what is in the dockets.
Yes?
It's the evidence in the dockets. They respond in terms of the evidence in the dockets.
Yes?
That is correct. So it's not additional information or extra information that was not made available to the panel.
Yes, I'm not talking about the docket. I am talking about the indictment. Because your report goes on about criticizing the indictment. But I'm saying that criticism of the indictment is deficient because it does not have access to the full indictment.
And the response to further particulars?
That is what I'm talking about.
It would refer to the content of the dockets.
How does that answer my...
As your charge sheet, sorry, I didn't mean to break your word, as with the charge sheet, your charge sheet ordinarily would not contain each and every piece of evidence that is in your docket. And if I understand it, a request for further particulars is for the defense to request more information on the charges of the indictment. So your request for further particulars and your response thereto, every response thereto will emanate from the evidence in the docket. You cannot have anything else other than that.
Yes, I don't think, I'm going to ask you for the last time. Your criticism of the deficiencies in the indictment were themselves deficient because they did not read the full indictment, because a response to a request for further particulars is part of the indictment.
I do not agree,
Yes.
and for the reasons that I've stated.
Now, if you actually go to the portion I wanted to take you to, which is you go on in your report challenging the indictment because it does not sufficiently flesh out the management role of accused 1, 6, 9, 15, and 16, Boysen, Mr. Major General Boysen, Captain Olivier, Captain Eva, Captain Lockham, and Captain Van Tonder. Captain Eva is no more. 4 are remaining. But if you had actually read the response to the request for further particulars, you would have got all of the information. Let me show you where it appears. Let's go to that. Start at 1332.
Yes, I'm there.
If you are at 1332, you will see paragraph 5.1.
That is correct, yes.
And the defense asked, why are you saying these people are managing the enterprise? Precisely the question that was raised in your report. The state answered, yes, accused 16 managed the activities of the enterprise together with accused 1, 6, and 16, who were the co-managers of the enterprise. Whenever any of them would not be at that particular scene, the most senior member would fulfill that management role. In count 8, accused 4 had more information from his informer and then shared it in the briefing with other members at Pietermaritzburg before they set on tracking Magojela and Tembe. Accused 8 was a passenger in pursuit car 1, driven by accused 4. Accused 9, 15, and 16 created an environment where other members of the enterprise could function to advance the objectives of the enterprise. So here is your first answer. We have charged these people as managers because their job was to create an environment for the fulfillment of the unlawful activities by the...
Full that management role.
Well,
There was no evidence in any of the docket where accused 9, 15, or 16 created an environment where other members of the enterprise could function to advance the objective of the enterprise. If I've come across a statement of that nature, I would be able to tell you that.
all right, well, let's carry on. 5.2. Accused 9, 15, and 16 created an environment in which the activities of the enterprise could take place by giving his members access to resources without engaging the unit commander, knowing that he has the blessings of the provincial commander. So there is your evidence. Major General Boysen skipped the unit commander to provide resources to the members. And I can show you now where the documents are.
All I'm saying is there's no statement to that effect. That if that is a reliance primarily on Colonel Aya's statement, and we have discussed the reason why we say why we do not believe that it will muster
No.
Colonel Aya.
Yes, no, I know
There's
that.
no evidence to that effect.
I know that.
I would still,
Carry on, finish.
sorry, can I just repeat? So
Yeah.
I would just say there was no evidence or no statement to that effect, and you can't read it into Colonel Aya's statement.
Yes.
That he was giving that Boysen was giving access to resources.
No, we will.
Because he was the unit commander in any case.
We will go
commander.
through. We will go through the underlying evidence. I know that you are criticizing Colonel Aya, but what you can never say is that there is no evidence. You can say that I don't like the evidence, but you can never say there is no evidence. You will just be blind to the facts. I'll come back then to 5.1. 5.21. The enterprise remains the same and continues to be the same in all of its activities. In this incident, now this is the incident of the killing of Mr. Magojela, Ndimande, as well as Sibusiso Tembe. The accused persons who participated in the enterprise are accused 1, 4, 5, 6, 8, 9, 15, and 16. They continue. Accused 4 ensured that all the participants are briefed and updated as to the latest information regarding to the movements of the suspect. He was the driver of the pursuit car number 1, the silver BMW. He pulled his vehicle, came to a standstill. He went closer to the driver's door and fired shots towards the driver at close range. Again, you've been told that this was his role. Briefings and updates as to the latest information regarding the movements of the suspect. Accused 9,
That's
15,
normal
and
police
16.
work.
Sorry?
That's normal police work in terms of if you are going to try and track and trace a suspect, there's communication between the police officers regarding and the sharing of information. Unless you can provide me with a report from inside where somebody said that is what happened regarding accused number 4, Mostert, giving information that does not relate to the tracking and tracing of that suspect, then I will accept it. But for me, it's the police has to share information.
Yes, but what
And
is...
that doesn't mean, sorry, let me just repeat, but that doesn't mean that that necessarily amounts to an unlawful act on his part or show that he was part of management or part of the illegally gave information.
Shouldn't you wait for counsel to take you where he wants to take you, madam? Because you earlier answered that there is no evidence. Maybe you should wait for him instead of take it from there. And if you can answer briefly to the questions, please.
Yes, thank you, Madam Chair. Now, if you go further down in that statement, I'm still explaining to you how the indictment described the leadership role or the management role. At 1334, 5.6.1, it says the work and functions of each persons employed by the enterprise or associated with the enterprise can be summarized as follows. Accused 5, Eric Nell was part of pursuit car, fired shots in the direction of the Hyundai with his R1 after the vehicle came to a standstill. He secured the scene. Accused 2, Pumelela Makanya, was part of the pursuit car and also fired shots in the direction of the Hyundai. Now, I would admit that those are the shooters. Those are the people that execute. Accused 15, Anton Leckham, was the driver of the pursuit car, the gold Toyota Corolla police vehicle with registration number ND309345, and was driving behind the silver BMW driven by accused 4. So here he is described as an enabler of the shooters. Accused 16, Eugene van Tonder, was part of pursuit car 2 and fired about 7 shots towards the Hyundai with his R5 rifle. Boysen supplied information on Magojela's whereabouts to Paul Mostert and arranged the helicopter flight after Magojela was located on the N3 highway, where he landed immediately after the shooting. Olivier accompanied Boysen in the helicopter and alighted at the scene. Accused 4 managed the tracking, tracing, and ultimate shooting of the deceased Magojela and Tembe. He started when he instructed the owner of the VIP protection that was providing security services to the KwaMaphumulo to remove their securities from their members. Now, you've been told what each player is, what each member is doing, and what the managers are doing in providing an enabling environment. Now you say, well, show me the evidence. Let's do that now. Firstly, I want you to look at page 2250, item 32.
Page?
2250. In volume 6, Madam Chair. Now, you've seen this document before, correct?
I'm still waiting on the document.
Oh, I see.
for the record, you can tell us what the document is?
The document is a letter headed Monetary Rewards, dated the 15th, I think 16th of October 2008, signed by Director Boyson, JW, addressed to Assistant Commissioner P.T. Brown of the Detective Services, KwaZulu-Natal.
I think this is the same document that I earlier on referred the witness to, and she read the entire
Yes.
document into the record.
Thank you, Madam Chair.
You remember, Advocate Riley, I referred you to this document earlier from a different bundle, I suppose, but the contents are the same, and you read from paragraph 1 to paragraph 7. Do you remember?
I remember, Madam Chair.
Has it been placed before you again?
I am looking at it now.
Yes.
Yes. Now, there are two things I want to explore with you about this. Remember that I've taken you to the response to the request for further particulars, which says Major General Boyson's primary role was to enable the commission of the offenses that form part of the pattern of racketeering activity. In other words, the killings, correct?
That is what you allege, yes? What's in the papers, yes?
I don't allege anything. That is what is in the response to the request for further particulars.
That is correct, yes?
Yes. Now, in that role, he says the solving of this case was widely reported and applauded by the media and public alike. It most surely restored faith and confidence in the SAPS to deal with ruthless killings. So the first thing he is doing is to praise and reinforce the conduct of the police who were involved in that operation, correct?
Yes, he praised him.
Yes. Then next thing he does is in paragraph 7. Not only does he praise and reinforce them, he also offers them money, correct?
He makes the recommendation, yes, that they be rewarded.
That they be given money. Yes.
That is, he makes that recommendation, yes, I agree.
Now, you would agree that that role is completely compatible with the role of enabling a person
If he
praise a
believes
person.
that it was unlawfully done, then I will agree with you. But if he believes that it wasn't unlawfully done, then it's simply a commander that is recommending his members to be rewarded.
I've not asked you about whether he believes it was unlawful or not. And we were doing well so far when you answered the questions. Once you introduce your own things, we're going to be here until 12 midnight. The only question I'm putting to you is this. This function of praising a member and recommending their reward is compatible with enabling them to perform a function.
I disagree with you, and I will say it for the same reasons that I can understand. There's two aspects here. The one is, if you believe or you knew that they were committing crime and he still recommends them, then I will agree that it's you're right in terms of that. But if it's not, if he believes that they were not committing crime, it's then simply the recommendation of members to be rewarded for cash.
Yes, but let us assume he did not believe they were committing a crime. He is still enabling them to perform their functions.
The functions, the normal functions, yes.
Yes. Now, the question here then is whether or not he had enough evidence that this was commission of a crime. Is that correct?
That is correct, yes.
Now, we then go to the next document, which is 2251. Can you see that? Can you see that document? The next
Just
page.
hold on. Yes, yes.
Now, this is a document entitled Monetary and Non-Monetary Awards. for the attention of Director Boysen, who is the Provincial Commander of Organized Crime in KwaZulu-Natal, correct? Is that correct?
I'm reading. That is correct, yes.
Yes, and the candidates to be rewarded, the first candidate is Director Boysen, correct?
That is correct, yes.
And they are all rewarded for allegedly solving the Maphumulo case, correct?
That is correct, yes.
Now, how did that happen? How did they solve the Maphumulo case? You go to the following page, which is page 2253. Correct?
I'm going there. I'm there.
And then under paragraph 3, they talk about the apprehension of 2 more suspects, correct?
That is correct, yes.
Now, we know that that is false. Those alleged suspects were not apprehended, they were killed. Is that correct?
That is correct, yes.
Now, under the summary of events, the first person who passed on the information and started off the entire operation is who?
Director Boysen or Major General Boysen.
Exactly. Now, look at how they describe then what happened at the actual scene. Page 2254. I want to read this because it's a very, very, very important passage. It says, the investigation team, that's the second sentence, which at this stage consisted of Inspector Mostert, Nell, and Makanya in one vehicle, while Captain Van Tonder, Lockham, and Eva, whom followed in a separate vehicle. Inspector Mostert managed to catch up to the vehicle, and in an attempt to get the suspects to pull over, the official blue light and the siren was used. A shootout then took place between the passenger of the suspect's vehicle and the investigation team, resulting in the driver of the vehicle being injured in the process, which resulted in the vehicle stopping. Do you admit that there is no statement there that says that the people inside the vehicle shot at the police first?
That is correct. I simply refer to a shootout between the passengers of the suspect's vehicle and the investigating team.
Yes,
They don't specify as to who shot first or...
No, I
That is
understand
correct.
that, but again, that's not my question. My question is there is nothing there that says the suspects, the alleged suspects, shot at the police first.
My understanding, a reading of a shootout then took place between the passenger of the suspect's vehicle and the investigating team. My understanding is there is a to and fro shootout between the suspect's vehicle and the investigating team.
All right, I'll ask you for the third time. If you don't want to answer, just tell me. There is no sentence there that says the suspects of inside the vehicle shot at the police first.
Not first, yes, I agree with you.
All right, thank you, finally. Then we move on. Inspector Mostert, sorry, I've read that already. Yes, we move on. It says, the passengers, now the vehicle has stopped. That's the vehicle of the so-called suspects. The passenger in the suspect's vehicle during the shootout made an attempt to flee from the moving vehicle.
There's an attempt to flee, yes, I agree.
Yes. Well, there's nothing called an attempt to flee. You are either running away or standing. So he is running away. Now,
I don't read that.
Sorry?
I don't read it. There was an attempt to flee. So I don't know what the attempt to flee means.
Yes, well, okay, let's work on your assumption.
But you can read the whole sentence.
Yes.
Because it says that it resulted in him being flung
Yes.
out of the moving vehicle.
So, Advocate Riley, we have a suspect, so-called suspect, who's a passenger. He attempts to flee, which means he tries to get out of the vehicle so that he could flee. But unfortunately, he gets flung out of the vehicle, correct?
That is correct.
Yes. So what we are dealing with, which is the second part, is a fleeing suspect or a suspect who is attempting to flee. Look what they say happens next. Both the suspects were fatally injured in the shootout. The driver was positively identified as Timson Nkabinde. We've read this throughout. There is not a single reference that Mr. Nkabinde ever attempted to shoot at the police. If you can find it, show me.
In this passage.
Yes,
that
this
we're
is the
reading.
passage that is describing what happened.
No, they don't. In the passage
Yes.
that is describing, they're not saying that he fired at him.
Yes, the first
They
time.
simply refer to a shootout.
Yes, the first time we hear his name is when he is fatally shot.
That is correct?
Yes. And then we talk about the passenger. The passenger is also fatally shot when he is attempting to flee. Is that correct?
That is correct, yes.
Now, this is the whole point then. You can read the rest of that. The driver was positively identified as Timson Nkabinde and was the main brain behind the assassination of Superintendent Tongo. The other suspect was his bodyguard. In both of these killings, at the time this was made already in 2008. There is absolutely nothing in this letter that shows that the police were under threat. That shows that the police were being shot at. That shows that the police had no other alternatives but to kill these suspects. What we have is the most extraordinary thing of killing a fleeing suspect, which I would submit to you is clearly illegal.
On what you're interpreting in the submissions for a reward.
Well,
No. Advocate Riley, please just confine yourself to the question, please.
do you want me to repeat, perhaps?
Madam Chair, my question still remains. There's evidence in a docket, and then
it's not
there
your
is.
question. You are not asking questions, madam. You are answering questions. I'm saying
But I do not.
to you, try to confine your answers to the questions that are posed to you. Counsel, just repeat the question.
Should I repeat, Advocate Riley?
Yes, please repeat.
Thank you, Madam Chair. Advocate Riley, I am putting to you a simple proposition. On this document, the police shot a fleeing suspect or a suspect that was attempting to flee and was flung out of the vehicle. They shot Mr. Nkabinde without any reference to how he posed any threat to them. That's why I've said to you, this is very important. Let's go through it together. Correct?
On this paragraph?
Yes, on this document as a whole.
How it's described. I will
Yes.
agree with you. And that is, and I still say, we worked with what is the evidence in the docket.
I am not
Not this.
asking on what you worked on. That's not my question. I am reading to you the document because I'm going somewhere else, not where you think I'm going.
That is correct, if based on the document, yes.
Precisely. And then we go back to where the document starts. Major General Boysen rewards these officers on the strength of this document. Remember the reward I started with of 10,000 rands, which is page 2250. And not only does he reward them, he himself benefits from them, from the reward. Now, this is in circumstances, they sit there in the office, they're paying themselves money. They have a document that shows clearly that a fleeing suspect was shot and that this was illegal. At the time, he took the money and he approved the money for the others.
I don't know, what am I supposed to say in terms of this document? This document is not the evidence in the docket.
I am not talking about the docket. You remember what we are talking about. We are talking about an enabler of unlawful activities being Major General Boysen. You kept on saying, show me the evidence. I told you that, wait, I'll show you the evidence. I've now shown you the evidence.
This is not evidence.
You are shifting the goalpost now, talking about the dockets. Here is the evidence. It's direct, original evidence.
A letter for the rewards is not the evidence. That is different from the evidence in the docket. How people write up their reports, that cannot be. That must be compared with what you have in the docket.
Well, this is even stronger than witness statements prepared after the event, because this one is authored by the very same people at the time, even before they knew there was an investigation. So this is the most honest account of what happened. Signed by Major General Boysen, supported by all of these other officers who got it. Now, you've shifted the goalpost again. Oh, no, it's not evidence.
Because I work on what's in the docket and what is a docket says in terms of the evidence.
Did you realize?
I cannot agree with you. Sorry, can I just
No, it's fine.
continue? I cannot agree with you. I cannot agree with you that a summary or a summary of what was transpired there in a document for rewards is either similar or better evidence than what is in the docket.
I understand that. I am not talking about the docket. I'm simply talking about Major General Boysen enabling the commission of crimes because he knows when he reads this letter that something wrong has happened here. Because the first thing he must ask himself, why did you gentlemen shoot a fleeing suspect? But no, he approves the payment, he pays himself as well.
Do you have any comment, Advocate Riley?
I don't agree with the submission by advocate.
All right, thank you. Now you've got another point you've made. You are saying this information was not in the docket. Are you serious about that?
I never said this information was not in the docket. Are you talking about the paragraph that you read out?
Yes.
I never said that.
All right. I thought you said that you didn't work on a letter. You worked on what was in the docket. But you admit
That
that
is
this
correct,
document
yes.
was in the docket.
This document pertaining to the rewards was in a docket. Yes, it was in Durban Central, 85. That's
you.
where I read this docket, all the statements in respect of the rewards.
Thank you very much. And what I found striking is despite your claim that you were very diligent, you never actually engaged with what I have read to you in your summary, including in your SR5.
No, I didn't.
Yes, thank you very much. Now, you know why we ended up on this route is because you refused to accept the submission I made that the indictment, when it is read together with the response to further particulars, places Mr. Boysen at the center of conceiving, strategizing, managing the commission of these crimes. And it is a lie that he came after the event. He was there at the beginning. Do you have any comment on that?
At which event, sir?
The killing, we're talking about one event, please. It is the killing of Mr. Ndimande and the killing of Mr. Tembe, because that's the crime that he is charged with under the racketeering offenses. It's those two murders. I'm saying to you, it is a lie that Major General Boysen came after the event. He was there at the beginning, he oversaw it, and then he came afterwards, and then he wrote a letter to congratulate the members and then to motivate for their payment.
We could not find any evidence to that effect in any of the dockets, in particular the Howick docket.
Yes, well, because you decided to ignore the existing evidence.
The evidence in the docket?
Yes.
Where there was no evidence that he was on the Howick scene before the time, or that he engaged with people. If it was done in the course of his duty as a police officer. There's no evidence from any witness that said that he engaged with him other than knowing that they are tracking and tracing certain suspects.
Well, you know what? I first accused Major General Boysen of lying. I'm going to accuse you of doing the same thing. How can you say that the only offense of Major General Boysen is knowing that these people are looking for the suspect, when we have just read the original letter that says he is the one who got information from an informer and passed the information to Mr. Mostert?
That is correct. But that is exactly what I said. If he was not on the crime scene, and if he provided any information regarding the tracking and tracing of a suspect or handed over that information, it was part of his duties as a commander or another police officer. Because I thought we also agreed that my submission was that I understand that that is the manner in which the police operate.
Yes. Advocate Ngcukaitobi, I'm sorry, I really tried not to interfere or interpose, but I have to ask this question. Advocate Riley, you keep on referring us to the fact that if Major General Boysen did this, he did it in the course and scope of his duties as a police officer. And I don't think that is in dispute, because these people, this group of people were all police officers. All do you appoint a police officer? All appointed as police officers, all carry South African Police Services badges and use police services firearms. So they were doing all this under the pretext that they are carrying out their duties as police officers. Hence, there are case numbers where they say they are investigating the murder of Superintendent Konko and. So you keep on going back to that answer that if Major General Boysen shared the information, he did that within his scope and duty as a police officer. But would you say the same where let's say Inspector Mostert shot, Inspector Mostert shot at the occupants of the Hyundai, in the case that is under discussion, is it in the scope of his police official duties, and therefore he cannot be blamed for such an act?
If I understand if he shot at someone and that person then it would be, and that person has never shot first at him and he was acting in self-defense. But if it was not the case, then I would agree. Yes, he did not act in self-defense, and therefore that can never be during the course and scope of his duties as a police officer.
And what about the information that Director Boysen gave to Inspector Mostert pertaining to Magojela and Tembe, and which led to the group of police officers cornering them and firing at them, ending up killing them? Would that still be within the scope of his duties as a police officer?
If the suspect, whether with or without a warrant, the police was looking for that person, tracking and tracing of that person, and Major General Boysen, as the provincial commander or as any other police officer who has information about where the suspect is provided to another police officer, that will be during the course and scope of his work, unless it can be proven through evidence that they, in actual fact, gave that information with the intention to go and kill that person, and that person wasn't being sought by the police, or even if the person was sought by the police.
Advocate Riley, I think I need to put this on record. Your answers take me by surprise, because you are a prosecutor, and one would expect that a prosecutor would go after a suspect with all the resources that he or she can, with the aim of bringing a suspect before a court. But it seems as if your position is that a suspect can be killed. And as you said earlier when you and I had an interaction, that once a suspect is killed, the case is solved. That is a bit unsettling, especially in this democratic era that we're living in. That is, I thought I should put it on record that it is, for me, it is a bit unsettling if we still hold such views. Thank you, Chair.
Madam Chair, I propose... Okay, sorry.
May I reply, or am I not allowed to reply?
You may comment.
Thank you. We're working on evidence, and I did not say, as a prosecutor, you can be allowed to go and kill somebody if you're a police officer. I simply said it's the norm of the police during their working that they will give information regarding the tracking and tracing of a suspect. There can be two scenarios. I said the police officer has a right to defend himself if he gets shot. If he wasn't shot at and he killed that person, then he is liable. Then he did it without any, then you can't claim that he acted in self-defense.
Do you remember the passage that you read at page 2254? In that letter from the South African Police Service relating to the monetary and non-monetary rewards?
That is correct, Madam Chair.
In which a summary of events is given by the police themselves? If you look
That
at
is correct.
page 2254, you remember that statement in relation to which a suspect was attempting to flee and he was thrown out of a moving vehicle. This is what the police are saying. And he was subsequently, immediately thereafter, shot at. You remember that passage? There is nowhere in that passage where a suggestion is made that these two suspects were shooting at the police, and the police, as they fatally shot at them, were defending themselves. You remember that passage at 2254?
Madam Chair, if my understanding of a shootout is between, there was
No.
to and
Do you
fro.
remember that passage?
I do. I
There
read
is
it.
nowhere in that passage where a suggestion is made that the suspect were shooting at the police and the police acted in self-defense. If I am missing something, please direct me to the relevant part at 2254.
At 2254, starting from the line right at the end of line 5, it says a shootout then took place between the passenger of the suspect's vehicle and the investigating team, resulting in the driver of the vehicle being injured in the process, which resulted in the vehicle stopping. So I do say I don't know if there's agreement. For me, a shootout is between two groups of people. And the way they describe it, there was a shootout between the passengers of the suspect vehicle and the investigating team. So my reading, unless I'm incorrect, is that there's shooting between the two vehicles, the investigating.
Do I find a line that says the police were shot at and they acted in self-defense?
It's not said that they acted in self-defense.
Thank you, Madam Chair. I propose to really move from this topic. I think the last exchanges have put everything we need to know about the approach of this witness clear. Now, can I also ask you something that is common cause, just to get your confirmation? The police killed 8 people in response to the investigation over Superintendent Ncukaitobi's murder. Do you remember that?
That is correct, yes.
They did not arrest a single person.
That is correct.
Yes. In relation to the killing of Nkosi Zondi, which was the Peggy Temba case, the police killed 3 people, correct?
That is correct.
They did not arrest a single person.
That is correct.
Yes. The person who oversaw the Zondi investigation was General Boyson.
Yes, I can confirm that.
Yes. His own statement appears in the Peggy Temba docket.
That is correct, yes.
Yes. He also oversaw the Konto investigation because he alleged that both of them were high-profile investigations that required his personal attention.
That's quite possible, yes.
Not possible. It is in his book, Advocate Riley, which was published 3 years before your report.
Now, maybe I should rephrase. It's quite possible that provincial commanders, when you have high-profile cases, that they will oversee it or be in charge of it.
Okay, thank you very much. Now, when you look at that, that is 8 plus 3, 11 dead bodies, where Major General Boysen is the overseer of the investigation, out of 28 dead bodies. That's approximately half of all of the bodies we are dealing with. You want to tell me that Major General Boysen had no knowledge that these were unlawful killings?
I cannot take it further except what I read in the dockets.
Yes.
And I had to decide on what is the evidence that he knew or ought to have known.
Yes, no, but the point I'm making, Advocate Riley, is simpler. The 2 dockets where Major General Boysen was personally in charge of had the highest murder rates out of every other docket we've dealt with. They had the highest killing rates where his hands were involved. It was the Konto docket that produced 8 deaths. It was the Zondi docket that produced 3 deaths. Those were the highest in proportion to every other docket. That's where Major General Boysen was personally in charge of the investigation. And you want to tell this panel that he had no knowledge about what was going on in the dockets that he was personally assigned to investigate.
That is correct. If there was evidence to that effect that he knew or ought to have known, then I will give you, I will agree with your submission.
I have just shown you in relation to the Konto investigation, the killing of Mr. Magoja Landimande and the killing of Mr. Sbusiso Tembe, where he knew because he signed the letter of rewards. He knew that they shot at a fleeing suspect. What other evidence were you looking for?
You said he personally knew or he
Yes.
received the information?
He personally knew because he signed the recommendation for the payments.
You can't say personally knew. If you are a provincial commander, then you are going to receive information. You are supposed to receive information about incidents of this nature in writing.
Well, we've gone
So-
through that episode. I'm not going to repeat it with you, showing his personal knowledge. But it seems that your mandate is to defend General Boysen at all costs. Can I move on to something else? You've
I
given
just
us...
want to respond to, may I respond to that, Madam Chair, about
Yes.
my mandate?
Yes.
Yes, you may comment, ma'am.
I disagree with you in terms of my mandate. I don't know where you got that from in terms of what my mandate was.
Well, I'm getting it from your responses that are so defensive that you would even ignore plain evidence staring you in the face.
And I disagree that that is evidence.
Yes. You've given... Thank you, Madam Chair. You've given us a number of authorizations that are signed by Major General Boysen. They appear at item 33 of the cross-examination bundle, 2257 to 2303.
Can you repeat what you're saying about number 33, please?
2257 to 2303. It's a number of authorizations that are signed by Major General Boysen.
Document?
Yes, no problem.
Is Advocate Ngcukaitobi still with you there?
She's still with me, Madam Chair.
Yeah, she'll assist you.
It is at page 225. Oh, sorry, it's item 33 of the index. Volume 6, apparently.
Just place on record what these documents are.
Madam Chair, these are attachments to the statements of Advocate Riley, which appear to be requests for trip authorizations. And there's quite a number of them spread between two dockets, Durban North 151 and Mapumulo. And the Durban North one seems to be an investigation into a robbery in Sibaya Casino. Do you have them, Advocate Riley?
Yes. May I ask a question, Madam Chair? These documents doesn't come from me.
Well, they are attached to your statement. I mean, where do they? That's why it's called SR. That's meant to be for you.
It was never attached to my statement. I'm sorry.
Well, they are attached to your statement, all of these documents.
I never attached this to my statement. I don't even refer to this in my statement. I don't know where these documents come from.
Well, can you go to your statement at SR2?
SR2.
Let's just get this right. My researcher is taking me to the annexure, the answering affidavit by Advocate Abrahams, to which these documents are annexed. Do you get that? Advocate Riley, you have annexed.
Yes,
You have annexed. Listen to me first, please. You have annexed Advocate Abraham's answering affidavit to your statement. And I'm advised that SR 0798 is an annexure to that answering affidavit.
Okay, I do understand now.
Look into that. Do you find that, Advocate Ngcukaitobi?
Madam Chair, I need to also be directed. Apparently, that's correct.
Yes. It is volume file 3.
Yes, yes, we found it, Madam Chair.
File 3.
Yes.
Do you have file 3 there, Advocate Riley?
I'm just looking for it, Madam Chair.
Yeah, thanks to our researcher. Have a look at file 3. These are documents attached or annexed to your affidavit.
It's part of SR2.
Is it 2?
It's part of SR2, but it starts from the other boundary.
But this is file 4.
Yes.
Is Advocate Lekgeto winning?
That is correct, ma'am.
All right.
Okay.
Advocate Riley, at what stage are you now? Have you found the source of these documents?
I found it as an annexure, yes, to Advocate Abrahams's affidavit. Yes, that's correct.
But the Advocate Abrahams's affidavit is an annexure to your affidavit. That's the point that the chair is making.
That is correct, yes.
And that's how these documents ended up being an annexure to your affidavit.
That is correct, yes.
Yes. Now, I have...
It is correct that this is your document. In other words, it forms part of your founding statement.
That is correct, yes.
Thank you.
Thank you, Madam Chair. That's been a lot more productive than I've been able to get. Sorry, I apologize. Yes, thank you. Because the Advocate, I've analyzed all of these documents, starting from 0797, 0796, which is 2257. Sorry, 0798, if you look at the red coloring, which is 2257. And what I find with them is that there are requests for advance payment from KwaZulu-Natal, often to Pretoria, sometimes to Johannesburg, but for substantial amounts of money. And they are made primarily by Mr. Jeremy Martin, Mr. Olivier, Mr. Lockham, Mr. Eva, Mr. Van Tonder, and approved by Mr. Olivier and Mr. Boyson. Now, what I found striking about that is that these are all of the managers of the enterprise. They are the people enabling the movement of the officials. Now, they also claim substantial amounts of money. There is one claim for 90,000 rands, 92,000 rands actually. If you look at 2261, that's a claim made by Mr. Lockham. So if you look at the amount there at 2261, the amount is at the top, says total.
Yes.
Can you see there? Is it 92? Is that correct? That is 92,000.
That is correct, yes. Looks like it, yeah.
Yes. And then you go through, let's go to 2263. Now that's to the attention of Major General Boyson, but it's signed by Colonel Olivier, by Colonel Aya, who is in fact the unit commander. None of this. Now you remember when we started, I pointed to you where the response to the request for further particulars says, Major General Boyson and Colonel Olivier would skip Captain Ayer and go straight to the officers reporting to him. And we find that pattern here all over. The people that are approving is Olivier and Mr. Boyson, but the requesters are the people reporting to Mr. Ayer. How do you explain that?
Well, first of all, if you talk about the huge amounts, may I respond to that? Or do you simply want me to say that in terms of Colonel Ayer not being there?
No, I can't restrict your responses, but I am interested in the fact that these people are skipping Colonel Ayer.
I don't think you can base it simply on this document, unless you can indicate to me the operational requirements that it must have included Colonel Aya. What I do see from these documents, that there are applications for authority to travel. I sit on the projects meeting at DPCI. I'm part of those meetings. So I do understand that there's a lot of money that is required in order to travel and to do your investigations. What I see in terms of these applications, that it's applications to travel to different places to do investigations. I can't comment on what are the operational requirements when you do submit an application for authority, and I can't comment on whether they have skipped Colonel Aya in this regard. Because I see the application is addressed to the Provincial Commander, Organised Crime, as well as the Deputy Provincial Commander, DPCI, which is Major General Boyson, and the Provincial Commander, Organised Crime, KZN, is Brigadier Madonsela.
I mean, I can even make you one glaring example at 2282.
Sorry, 22?
82. And then look at who 2282 and 2283.
Sorry, I might be not, is it, I'm here by SR 0798 still, and you're referring me to?
No, to the blue numbering, well, the green numbering, 2282 and 2283. If you're looking for the red numbering, it's SR 0823 and SR 0824.
Okay, got it.
So, again, this makes the example I was trying to make to you that with none of these do I see the actual unit commander making any approval. All of them are from the people reporting to him, and then he is skipped and they go straight to Major General Boyson. So take this one. This one is from Mr. Olivier, if you look at 2283, but look at who approves. It's General Boyson. But in between General Boyson and Mr. Olivier is Mr. Aya. How do you explain that? If you deny that they used to skip him.
I indicated this is an application for authority to travel. I'm not familiar with what is the operational requirements when you do an application of this nature.
All right, so your point on this, you would accept the facts that Mr. Aya does not appear, his subordinates appear, but they are approved by Major General Boyson. Your point is that you don't know what the operational requirements are.
When you apply for authority to travel, whether it should go to Colonel Aya or whether it should go to the provincial commander directly.
Yes. Now, you would remember that one of the issues you have is that you cannot accept the evidence of Colonel Aya, who says, these people used to skip me and go to Major General Boyson on inter alia traveling requests. And I've now shown you the evidence, what he means by that. Can you comment on that?
That's what he says, yes. They skipped him.
Yes.
That's what I read in his statement, yes.
Yes, but I have shown you the evidence because you have this tendency of saying, I want to see the evidence. I've shown you the evidence. You now say, well, you want to see the operational plan.
That was my response was, I do not know the operational requirements when you do an application for authority to travel.
Can I move to another topic? Thank you, Madam Chair. Can I move to another topic, which is in your report, you say, because Major General Boyson was charged with predicate offenses arising from the same incident, that would not qualify under POCA as being two or more offenses, correct?
That is correct, yes.
Now, you also rely on this judgment of Watts versus State. It's a Florida case. Now, I want to take you to that judgment of the cross-examination bundle. 2317, volume 6.
We're just looking for it.
So if you go to Anthony Watts versus the state of Florida.
Before that, did you find it, Advocate Riley?
Not yet, Madam
It is
Chair.
in that same volume in which the trip authorizations or applications were made towards the end of that bundle. 2317.
Yes, sir.
Now, this is the case that you rely on in your report. And in fact, if I recall correctly, even in your statement, you rely on this case.
That is correct, yes.
Now, if you go to, yes, that same page, 2317, you read the judgment where it deals with section 895.02 brackets 4 defines a pattern of racketeering activity as, can you see that?
Hold on.
It's in the middle of that page. And it starts with the sentence, section 895.02 brackets 4 defines a pattern of racketeering activity. Can you see that?
That is right.
Now, how does it define it?
Sorry, let me just... defines a pattern of racketeering activity as engaging at least 2 incidents of racketeering conduct that have similar intents, result, accomplices, victims, or methods of commission, or that otherwise are interrelated by distinguishing characteristics and are not isolated incidents, provided at least one of such incidents occurred after the effective date of this act, and that the loss of such incident occurred within 5 years after a prior incident.
Yes,
Of racketeering conduct.
Precisely, thank you. Now you see the question on appeal, it's dealt with in the next paragraph. What was the question on appeal in that case?
The question of appeal is whether the 2 incidents requirement is satisfied when the state proves that the defendant is guilty of 2 offenses which arose out of the same incident. We find that this does not satisfy the 2 incidents requirement.
Yeah, stop there.
This issue...
All right, well, I mean, you can continue if you want to read about State versus Russo. I don't want to stop you.
Now, the issue was addressed in State versus Russo, 493 SO2D 505, FLA Fort DCA 1986, review denied. 504 SO2D 768 FLA 1987. In Russo, the court held that the 2 incidents requirement is not satisfied when the defendant is charged with 2 offenses which arose out of the same transactions.
Yes, the Russo court stated that its interpretation is in line with the Florida Supreme Court's determination. Can you say that?
That is correct, yes.
Now, we go back to that definition. You see the judges are making it clear that they're distinguishing between two incidents and two offenses.
That is correct, yes.
Now, can I ask you to go to our legislation, not the Florida? This is the Florida statute that you've been reading, not the South African statute. Now, can I ask you to go to page 275 of that same bundle and look at how we define a pattern?
Which page?
Commissioner,
Which volume?
Volume 1, Madam Chair. So if you are at 275, under the definition of pattern of racketeering activity.
yes, it means the planned, ongoing, continuous, or repeated participation or involvement in any offense referred to in Schedule 1 and includes at least two offenses referred to in Schedule 1, of which one of the offenses occurred after the commencement of this Act, and the last offense occurred within 10 years, excluding any period of imprisonment after the commission of such prior offense referred to in Schedule 1.
Now, can you see the clear difference that the Florida statute refers to incident? The South African statute does not refer to incident, it refers to offense.
That is correct, yes.
Now, can you then explain why you used the Florida statute and not the South African statute?
I refer to a case in terms of what they describe as two incidents.
No, the case, as I've shown you now, the case you've referred to is Anthony Watts versus the state of Florida. It took
That
the
is
definition
correct,
from
yes.
the statute and put it in the judgment. That's why I ask you again, why did you use the statute? That is why they say, if it is two crimes from the same incident, that amounts to one incident. In South Africa, the word incident is not used, but the word offense is used.
That is correct, yes.
Can I come back then to ask you the question? Why are you applying Florida law when we have clear South African law?
If you can refer me to a South African case that deals with this issue rather regarding the planned, ongoing, continuous, or repeated participation, then I will agree that there are differences. But my understanding was in terms of proving a planned and ongoing, continuous, or repeated participation does not refer to a single incident, because the idea is regarding a pattern of racketeering activity is that you are involved over a continuous, ongoing, repeated participation in these offenses. And it does not refer to one incident with multiple counts. It refers to many more.
Yes. All right. And you want me to refer you to South African authorities. You did not read them yourself.
I said if you can refer me